Hi, my name is Dr. Devaruti Haldar and I'm the Honorary Managing Director for Center for Cyber Victim Counseling. In this video, I'm going to discuss about the salient features of Information Technology Act 2000 amended in 2008. First, understand the origin and development of Information Technology Act. Information Technology Act or IT Act owes its origin to United Nations Commission on International Trade Law or Unilateral Model Law on Electronic Commerce 1996. In 1999, Information Technology Bill was introduced for the first time in India. In 2000, Information Technology Act or IT Act was introduced. In 2006, IT Act Amendment Bill was introduced and in 2008, the present form of IT Act 2000 amended in 2008 came into existence. Let us now discuss about the purpose of IT Act. Number one purpose is to recognize online transfer of data. The second purpose is the e-governance. The third purpose is to strengthen cybersecurity. And the fourth is amendment of IPC, Indian Evidence Act and Bankers Book Evidence, etc. Why did IT Act 2000 had to be amended? There were many reasons. The primary reasons are narrowed concepts in the first version of IT Act, rapid development of cyber technology, and the growth of terror activities online as well as using the cyberspace. Now discuss about the salient features of the IT Act which can be done under 7 broad heads. These are short title, commencement, extent, scope, definitions, electronic governance, electronic commerce, civil liabilities, penalties, and criminal liabilities, penalties, etc., courts and tribunals for dealing with civil and criminal liabilities, electronic evidence and examination of the same, miscellaneous, which includes discussions on powers of the police, abatement of offence, attempt to commit the offence, etc. Now let us discuss the brief introduction to the provisions under the Information Technology Act 2000 amended in 2008. This law is divided into 12 chapters and 90 sections. Chapter 1 consists of 2 sections, namely Section 1, which provides the short title, extent, commencement and application of the law. Section 2 deals with definitions. Chapter 2 deals with digital signature and electronic signature. Chapter 3 deals with electronic governance. Chapter 4 deals with attribution, acknowledgement, and dispatch of electronic records. The discussions on e-commerce actually is covered under chapters 4 majorly and chapter 3 partly. Chapter 5 deals with secure electronic records and secure electronic signatures. Deals with regulation of certifying authorities. Chapter 7 deals with electronic signature and certificates. Chapter 8 deals with duties of subscribers. As such, chapters 3 to 8 deal with e-commerce and civil liabilities. Chapter 9 deals with penalties, compensation and adjudication. It therefore deals with civil criminalities, responsibilities for data protection, civil remedies for the same, etc. Chapter 10 discusses about Cyber Appellate Tribunal. 11 deals with offences. It deals with criminal liabilities at large and intermediary liabilities. Chapter 12 deals with intermediary liabilities and due diligence, etc. Chapter 12a deals with examiner of electronic evidence. Chapter 13 deals with miscellaneous, including power of the police officers to enter, search, etc., punishment to attempt to commit an offence, etc. Now, let us start discussions on Chapter 1. Section 1 deals with short title, extent and commencement of the Act. This section clearly mentions that Information Technology Act shall extend to the whole of India and also to the offences committed outside India by any person. This means that this law has intra-territorial and extraterritorial jurisdiction for any offence under this Act. Section 1 therefore extends its scope to offences committed by any person even when it is committed abroad. Section 1 can be read with Section 75 of the Information Technology Act 2000, amended in 2008. Section 75 extends the scope of the Act to apply for offence or contravention committed outside India. Section 75 Clause 1 says that the Act applies for offences committed outside India by any person, irrespective of his nationality. Section 75 Clause 2 states that the Act shall apply to an offence or contravention committed outside India by any person if the act or conduct constituting the offence or contravention involves a computer, computer system, or computer network located in India. Let us discuss about the difference between sections 1 and 75 of the IT Act 2000, amended in 2008. Section 1 of the IT Act deals with short title, extent, and commencement of the Act. In a way, it also deals with jurisdiction. Section 75 deals essentially with jurisdiction and scope of IT Act. According to Section 1, IT Act extends to the whole of India and also to the offences committed outside India by any person. Section 75 is conditional in nature, whereby it says that it can be applied when the computer, computer system, etc., which is targeted is located in India. Section 1 limits the scope of the Act to the documents or transactions as discussed below. These include negotiable instruments other than a check, power of attorney, a trust defined under Section 3 of the Indian Trust Act, a will defined under Section 2H of the Indian Succession Act, any contract of the sale of conveyance of immovable property or any interest in such property. Section 75 does not discuss about the limitations as Section 1.